Francesca will join us shortly. Excellencies, colleagues, and friends, good afternoon, and thank you for joining us for this side event entitled Economic Responsibility of Third States in Light of the ICJ Advisory Opinion and the Genocide Prevention Convention. My name is Ammar Dwaik. I am the Director General of the Palestinian Independent Commission for Human Rights. It's the national human rights institution of the State of Palestine, accredited with A status under Paris Principles. In this capacity, we are mandated to promote and protect human rights, both domestically and internationally, and to serve as a bridge between local realities and international accountability mechanisms. We are co-organizing today's session with our esteemed partners, Human Rights Watch and Law for Palestine, to emphasize that human rights cannot be defended in isolation from the systems, whether economic, legal, or political, that enable their violation. NHRIs, like my organization, are called upon not only to monitor abuses, but to advocate for systemic reform and accountability, including the enforcement of international legal obligations by third states and the private actors. As an NHRI working under occupation, we are acutely aware that the violations in Palestine are not simply the product of military operations. They are the outcome of a sustained ecosystem of structural violence driven by both states and non-state actors. This includes third states that continue to enable impunity through economic, military, and diplomatic support, and the private corporations whose operations and supply chains are entangled with illegal settlements, military logistics, and surveillance infrastructure. Today's session is part of our broader effort to shift conversation from rhetorical condemnation to legal accountability, from witnessing violations to dismantling the structures that perpetuate them. This discussion is grounded in international law. The 2024 advisory opinion of the ICJ reaffirmed not only the illegality of Israel's prolonged occupation and settlement enterprise, but also clarified that positive legal obligations of third states, particularly not to recognize the unlawful situation as legal, not to render aid or assistance that maintain this occupation, and to take effective steps to bring it to an end. Most importantly, our conversation today draws from the latest report of the UN Special Rapporteur on the situation of human rights in Palestine. We are privileged to have with us here Mrs. Francesca Albanese. The report is entitled From Economy of Occupation to Economy of Genocide. The report is published yesterday, and will be presented to the Human Rights Council tomorrow, which concludes that companies and private actors cannot shield themselves by claiming neutrality in conflict situations. International law demands that they actively assess, avoid, and remedy participation in human rights abuses or occupation-related violations, and failure to do so carries potential criminal, civil, and reputational consequences. Our aim is to translate international legal standards into enforceable action to ensure that not only perpetrators but also enablers of grave breaches of international law are held accountable. With this in mind, we are honored to host a distinguished panel who will guide us through a legal, ethical, and policy dimensions of economic responsibility in the context of atrocity crimes. I will introduce each panelist when the time comes for their intervention, starting with Ms. Anisha Patel from Law for Palestine, who will lay the ground for us today about the legal obligations of the states as third state actors. Please.
Thank you so much. We've been watching for over 600 days the genocide being committed by Israel against the Palestinian people in Gaza. As we've said several times before, this is a continuation of the settler colonial apartheid regime and the most violent phase of the 75-year-long Nakba. Legally, and at the cost of repeating what has been said again for more than 18 months now, but not made effective, we have the ICJ provisional measures orders in South Africa versus Israel, where the court outlines the plausibility of Israel committing the crime of genocide. In Nicaragua versus Germany, the ICJ has reminded states of their obligations relating to the Geneva Conventions, the principles of international law, and the Genocide Convention. Sorry. And the ICJ advisory opinion that Dr. Dwaik has outlined already, the ICC arrest warrants for counts of war crimes, crimes against humanity, and of course, for years now, the different reports by commissions of inquiries, the special procedures, including the right to food, and other factual and legal analysis that have articulated different facets of the genocide, apartheid, the settler colonial enterprise as such, and the unlawful occupation. All of this comes in addition to decades of violations documented and legally articulated by Palestinian civil society colleagues and international organizations. I know my colleagues will speak to the structural nature of the entrenchment of the Israeli economy in the occupation of Palestine, but I will kind of address it briefly, just to outline that the economy of Israel and its exercise in Palestine is deeply enmeshed in the settler colonial project, making the process of distinguishing between the Israeli economy and its entrenchment in the territory materially not possible. Key Israeli industries, including weapon manufacturers, high-tech industries, the financial sector, agriculture, and others, as have been articulated in detail, have directly benefited from and contributed to the occupation through the exploitation of Palestinian lands, resources, and labor. It is therefore untenable to meaningfully disaggregate and the engagement between the Israeli presence in the OPT and the state. So what does all of this mean in terms of economic responsibility for states?
It's on, it's already on.
I can't move it.
This is the close that you can get. Now, okay.
Is this better? This is better? Perfect. Thank you. So what does all of this that we have we've watched, witnessed, legally heard mean in terms of economic responsibilities for states? States, as main actors of international law, bear responsibility for ensuring that not only state organs, but also corporations and individuals under their jurisdiction are not in breach of international law violations, including extraterritorially. This means, at least from 26 January 2024, states have been alerted that there is, at the very least, plausible genocide being committed in the occupied Palestinian territory. And since July 2024, the court has reaffirmed the Israeli violations of peremptory norms of international law. This triggers a series of obligations for states and its organs. Primarily, states are obliged to employ all means reasonably available to them to prevent commissioning the acts of genocide. And this includes obligations to regulate the conduct of corporations that are domiciled in their jurisdiction and to ensure that they're not committing, aiding, or abetting genocidal acts. This is a duty of conduct on states. The prohibition to commit genocide as a jus cogens norms, from which no party, including corporations, can derogate. Finally, investigating and prosecuting entities and individuals accused of genocide, including by having the legal infrastructure and, very importantly, the will to do so, forms a part of the obligations emanating from the Genocide Convention. This is also a role that national human rights organizations have to participate in. Additionally, states have the duty under Common Article 1 of the Geneva Conventions to ensure respect for the convention by states and non-states parties, according to the ICRC and in line with the ICJ jurisprudence. The ICRC framework for private businesses in conflict articulates that obligation of states to ensure that people within their jurisdiction respect IHL and that those responsible for grave breaches are brought to justice is not limited to members of the armed forces. states must ensure that individuals and corporations within their jurisdiction do not commit, facilitate, or benefit from grave breaches of international humanitarian law. These grave breaches have been articulated by the ICJ at the very least, but again, have been outlined by the Palestinian civil society for decades now. These obligations extend to private persons, including the management and personnel of private businesses. International treaties require states to ensure that war crimes, including grave breaches of the Geneva Conventions, for instance, are enacted as criminal offenses in their national legislation. States have to investigate, where warranted, prosecute individuals and corporations who commit these crimes. The UN Guiding Principles in Business and Human Rights outline that states may also be found in breach of their human rights obligations where they fail to take appropriate steps to prevent, investigate, punish, and redress abuses by private actors when human rights violations occur. States therefore have an obligation to extend this regulation and oversight to the operations of corporations that exercise outside their territory in accordance with the general extraterritorial human rights obligations. And finally, in line with the responsibilities for serious breaches of Jus Cogens norms, as have been articulated by the ICJ in July 2024, states have three key duties. The first is a positive obligation on states to bring Israel's illegal presence in the OPT to an end, which translates into imposing sanctions as articulated through the UNGA resolution ES 1024, including travel bans, asset freezes against natural and legal persons engaged in the maintenance of Israel's presence in the OPT. There is also a negative obligation on states not to recognize as lawful the existence and continuation of Israel's presence in the OPT, which calls for states to suspend all economic or trade dealings that entrench the Israeli presence in the OPT. As my colleagues will articulate in some detail after this, this entrenchment is critical to the Israeli economy as a whole, which means making this distinction between the Israeli economy as is and Israel's presence in the OPT is materially not possible. Finally, states have a negative obligation not to aid or assist in the maintenance of Israel's illegal presence in the OPT. And again, given the impossibility of meaningfully distinguishing between this, any aid or assistance has to be seized. A complete embargo on all forms of aid and assistance to Israel as a general matter is therefore required that includes economic, military, technological, and diplomatic support. So to conclude, economic relations, both public and private, are central to sustaining and enabling Israeli violations of international law. These include investments, arms transfers, trade, supply chains, and financial services supporting Israel's genocidal campaign, atrocities in Gaza, and generally violations of peremptory norms of international law in all of the OPT. It is no longer a question of political convenience or legal ambiguity for that matter, and there are binding obligations on states to suspend all economic relations that support the occupation, including by imposing sanctions and to ensure that corporations and individuals in these violations are held to account. Thank you.
Thank you, Anisha, for sticking the time and also for your insightful presentation about the legal framework that regulates the work of states and non-state actors when it comes to violations to international humanitarian law. As mentioned, the Israeli occupation does not function in a vacuum. The genocide and the occupation are both supported from an economic structure that also benefits from them. Our next speaker, Mr. Wesam from Al-Haq, will present to us the structural nature of the settler colonial economy. Mr. Wesam, the floor is yours.
Thank you very much to the organizers for bringing this together, and thank you very much, Francesca, for all the work that has been done on this report, to you and your team, which we look forward to hearing more about after my intervention. So I'll try to be as brief as possible. With regard to the structural nature of the settler colonial economy in Palestine, I think it's important to keep in mind that we are not seeing something completely new. it's part of the history of colonialism. And when we look at this specific context, we see the Jewish Colonial Trust and its establishment back in 1899. But this draws on the history of the East India Company, the British South Africa Company, initiatives of people like Cecil Rhodes. So the refinement of colonialism through private actors is one that Israel has taken advantage of and developed through its continued colonization of Palestine. And we see in archival documents the discussions that took place early on in the development of the Zionist project. Specifically, one of the archival documents that I have here looked at the colonization of Palestine, the means and methods. What are the means and methods that should be used to colonize a country on a large scale? And the question that was asked is, should it be done by philanthropy or treated as a business proposition along strict business lines? And this is from 1925. We see how Israel and the Zionist project over time has refined this art of colonization, and it became very clear, I think, after the occupation of territories in 1967, that there was a conscious desire to continue this colonial project. Those of you that are familiar with the history recognize the name Theodore Meron, who was an advisor to the Israeli government that explicitly said the settlement project in occupied territory is a breach of the Geneva Conventions and contradicts the initiatives that have been taken by the international community to prohibit colonialism, the colonialism of the past. What Israel decided instead to do was form the Israel Corporation, which is basically a modern-day Crown Charter company to further its continued colonization of Palestine. And I think it's important to keep in mind that this happens at a time when you are seeing the demise of, I would say, the classical forms of colonialism, but at the same time, the emergence of neocolonialism and the neoliberal economic hegemony that we continue to struggle with today. And the fact that these things happened simultaneously, Israel making a conscious decision to continue a classical colonial project, but making use of the emergence of these new international economic tools that allow it to refine this art of colonialism and what I call the best business practice of colonialism. And this is the structure that has been developed. And we have seen that evolution of making use of all these different economic measures and foreign direct investment and the like, which will be elaborated on by Francesca and obviously a lot more in the report. But before transitioning to the report, I want to bring specific emphasis, I think, on the value of this report in helping us to understand the system that we are challenging. When we talk about challenging a structure, we need to understand that structure. We need to understand its constituent components. And this report, I feel, helps to elaborate and give us a better understanding of the system. This is something that we have been endeavoring to do for years, putting together diagrams that try to reflect what this structure looks like, how it interplays with one another, and whether we look at it as an architecture of a building or a machine that is operating through these different parts. By understanding how all these things come together, we're better able to identify the weaknesses within that system in order to be able to challenge it. And the more information that we have in understanding how the system works, the better we can be equipped to challenge it especially in this context of an asymmetrical power dynamics which we have. Now, identifying the weaknesses is one thing, but it's also important to keep in mind how we need to overcome the obstacles. And we have to identify those obstacles. And the key obstacle, I think, first of all, when we are looking at international law, is its application to corporate actors. This is a continuing gap that we have been struggling to fill because international law does not put on the corporate actors the same obligations as states, obviously. And our work in collaboration with others like the Global Campaign, ESCRnet, TNI, and the ETO Consortium have been trying to get the open-ended intergovernmental working group on business and human rights to formulate a binding treaty. And I think this is one of the biggest gaps that needs to be filled, is having international law apply in a much more direct fashion on corporate actors. And this way, we will be able to show and strengthen this connection between the host states and the home states, and that creation of a duty of care between those corporations that are operating in one country. What obligations do they have to victims in another country? And domestically, and I think this is more important, because we have seen the failure in the trickle-down effect of international law. We talk about international law, and when we study it, we see it as this oasis that we are striving towards. And then once we start implementing it and using it, it turns out to be a mirage, that it actually isn't tangible. It doesn't bring us the tangible results that we seek. And I think it's our responsibility to endeavor into understanding where these gaps are, not only at the international level, but also at the domestic level. And I just want to highlight two of the main domestic obstacles, I think. One, in the criminal law, the issue of prosecutorial discretion, and one in the civil law, which is the doctrine of international comity. That's comity with ITY for the non-lawyers in the room. But basically, both of these allow for the taking into account of political and economic considerations. And when political and economic considerations are part of the calculus in moving towards accountability, we are always going to have an uphill battle, because the victims that are seeking accountability are in one part of the world, and the systems that we are seeking to use are in another part of the world. And the only way really to change that is to reduce that discretionary power that exists within these systems. But in order to do that, you need domestic legislation that creates this kind of strict liability of any association with this joint criminal enterprise, being the Israeli settlement enterprise, as one that will have consequences, and remove that discretionary power within the prosecutor and the judiciary, that will allow them to overcome these political and economic barriers and move towards accountability. And we know this can be done because we've seen it in other contexts. When there is a desire to go after a specific organization, within 2 days, that organization's website is down, their emails are cut. So we know that it can be done. The question is, where is the political will to do so? And it's not going to happen top down from international law to domestic law. It's going to happen from the national constituency and the power that you have as individuals within the various jurisdictions to push for the filling of these gaps in international law. And I'll stop there. Thank you.
Thank you, Wesam. As I mentioned, Mrs. Albanese presented or will present tomorrow another groundbreaking report. The report is entitled "The Economy," or from the economy of the occupation to the economy of genocide. I will give the floor now to Mrs. Albanese, who needs no introduction, to talk about her report and the private corporation involvement in the genocide and in supporting and sustaining the occupation. Please.
Can you hear me? Good afternoon, everyone. I would like to start by thanking the Independent Commission for Human Rights of Palestine and Law for Palestine for bringing all of us here, inviting me with this distinguished panelist. And I would like also to take a moment to acknowledge the presence in this room of friends and colleagues from occupied East Jerusalem, occupied West Bank, and occupied Gaza, who so much are enduring, and including in terms of personal costs. Many of them have lost colleagues and family members, including in recent weeks. And I really want to thank you for being here and for continuing to trust us for what it's worth. I've been, also full disclosure, I'm not going to talk that much about my report because you have to come to the interactive dialogue tomorrow, and I cannot tell you what is in there, although it's already readable, but I would like to share you a few remarks. This is not the first time that I come to Geneva or I go to New York and I wonder, really, what else can I tell these people? Because frankly, especially to the member states, in the room, but also to the civil society, frankly. What are we doing? What are we doing? Because everything that this august organization represents is failing. Politically, I mean, if you're not able to stop, call it whatever you like, war crimes, crimes against humanity, genocide, pear and apple, it's fine. If we are not stopping what's going on in Gaza, in the West Bank, and East Jerusalem right now, this organization serves no purpose, honestly. And legally, what is international for if it's not applied universally, objectively? And more than this, humanitarian action. If someone has the nerve to call what Israel is doing in Gaza through that death trap, that looks more like a joint criminal endeavor than a humanitarian organization that is called the Gaza Humanitarian Foundation. If we let it work, let it kill, let it starve, and let it laugh at starving Palestinians amassing for a hand of flour, another day, another week, the meaning of humanitarian action will get lost. So here's the thing. We are facing, this is a moment of truth. Palestine is a revealer of our lack of meaning or of our meaning, of our purpose in life, in our professions. And this is a moment of truth. And truth demands not intelligence, as someone was saying yesterday. Truth demands courage, courage to dismantle what has enabled this. And here's my reflection on accountability. Because, again, there is an entire system that has been established and it has festered. And as Wesam from Halakha said, this is something that it's older than this building. And even the stones of these organizations, both here and New York, know the plight of the Palestinian people. The thing is that nothing so far has been done to address the system, the root causes, rather the contrary. Countries and even individuals and businesses and universities and charities and banks and pension funds are part of it. Again, over the past 6 months, and this is what I've exposed. If you can go back to the slide that was, sorry, thank you, Wesam. The system that I've tried to describe, and trust me, I had no idea when I started this investigation that I would end up with this. But this is it. I mean, this Israel, in the occupied Palestinian territory, has set up an economy of occupation made of two pillars or two wheels, a displacement and replacement mechanisms, which is made of private actors, which historically have been the drivers or the enablers of settler colonial exploitation, dispossession. This has happened in Australia, in New Zealand, in the United States, in Canada. And now it's happening in Palestine. The shocking thing is that it's still happening on what remains of Palestine. It has happened already to Palestine, and also what remains of Palestine as occupied land. So this is what is shocking. And even more shocking is that now, after 2023, 2024, I mean, this discussion can apply to Congo and many other resource-rich places, but Palestine is different. And this is why I'm saying it's a moment for real meaning of accountability. Because in Palestine, now we have ICJ rulings, 2 proceedings for genocide, in ICC arrest warrant for war crimes and crimes against humanity. Not against 2 individuals, against 2 state officials, one former, one still in charge. And plus, we know that Israel is plausibly committing genocide. What else? So, and we know because the ICJ has said that the occupation is unlawful. It must be dismantled totally, unconditionally. This is not a red line. It's a red highway. So in the face of this, I cannot accept that businesses come and say, oh, but we are not doing anything, it's Israel. No, you cannot provide means, you cannot be directly linked, you cannot enable, you cannot facilitate, you cannot profiteer from anything that is related to this monstrosity. Otherwise, you can continue, but you need to face accountability. And there is accountability in this purest and widest form. It's courts, international, regional, or national, but it's also us. Because if we are no power today, it seems, I'm talking to the peers coming from quasi-liberal democracies where we still vote, we do not have the power to stop a genocide by reorienting toward legality our government, and still we can vote through our wallet. What we buy, where we put our money, which insurance company we find, which company we use to go on vacation, normalizing occupation by a click. So again, this is a moment of reckoning. In my report, it's not groundbreaking, indeed. It's just a revealer as Palestine and wants to be a wake-up call. Palestine has put us in the face of a cusp. We have to choose now. I don't think that the right term is going back, because there is no going back. We will never get out of this phase. We will never get out of this genocide the same way we have entered it. But we need to veer toward a better path. Otherwise, those who have profited from the genocide in Palestine will continue to profit from continuing to looking at us, all of us, as people to be surveilled, to be contained, to be manipulated, and sooner or later to be defeated. Thank you.
Well, thank you, Francesca. I believe the fact that I come all the way from Ramallah, my colleagues, they come from Gaza, from Jerusalem, to this building, reveals that we still have some faith, although this faith is fading in the international system. And if it's not working, at least we Palestinians, we exposed it. And we exposed its weakness to the world that needs to act together to reform this failing system. Thank you. I'll move on now to one glimpse of hope for Palestinians and for those who seek justice, is to seek justice through domestic and national courts. I'll give the floor now to Mr. Grefte, Daan Grefte, from the he's a legal officer from the European Legal Support Center. He will draw on the rich experience of the center in providing strategic litigation and to see how strategic litigation can be utilized to bring accountability in the field of corporate involvement in genocide. Grefte, please.
Thank you so much. Can everyone hear me like this? Great. So I want to start off by just echoing what my co-panelists have already said. Thank you so much for the invitation to speak about this and for organizing this. I think it's important that all of you hear what is being said here. I will also try to keep it brief because I really would like to keep some time for the Q&A, and I think we don't have that much time left, so I will cut some things of what I was planning to say. First of all, I think that the co-panelists here have very clearly described what actually the role of economic actors is in the occupation of Palestine and in the crimes that are currently being committed against Palestinians. It has also been extremely clearly explained what the duties, the legal obligations are of third states in light of those violations and of those crimes. At the same time, I don't think I will surprise any of you here if I say that there has been no meaningful action whatsoever from the most powerful states and the most powerful members of the international community, which perhaps not entirely coincidentally also host many of those economic actors. And many of those economic actors are actually headquarters in those states that take the least action to fulfill these obligations. So the question was posed to me, what can we do about this in lieu of such meaningful action? What can we as civil society do? So I'm not going to pretend like I am the authority on this. I think there are many views on this and many visions, but I can certainly describe my own and that of the European Legal Support Center. I think the answer to the question, what can we do, is quite simple. I think that we need to make Zionism untenable. I think we need to make genocide, I think we need to make apartheid, and I think we need to make occupation untenable as an economic activity. And what do I mean by that? I think that we need to isolate Israel economically, politically, and then eventually also militarily to take away from them the means to commit the crimes against Palestinian people. So how should we do that? Well, first and foremost, and I think it should go without saying, but yet here we are, we should be following the lead of Palestinians in their own struggle to liberate themselves. And in practice, that means standing with them, even if there are risks for ourselves as well. Secondly, I think that we should be organizing and mobilizing support for a free Palestine and also escalate efforts of civil disobedience. So what I mean with that is occupy that university that develops military tech that is being used to destroy the Palestinian population. Block that port that sends weapons and bombs to Israel while it commits genocide. Try to make inoperable the arms manufacturers that make the arms that are being used to commit genocide in Gaza. And then finally, what we can do as civil society, and this is the role that the ELSC takes, but of course that is shared by many other colleagues who are doing very important work on this, is that we should support all of the above by making use of legal opportunities whenever they arise. So that means that we should coordinate with Palestinian civil society and organizers in order to make sure that we have the same strategies and the same targets for strategic litigation. It means that we need to make use of the legal momentum created by, for example, the ICJ advisory opinion, the ICJ genocide preliminary ruling, and of course the ICC arrest warrants. We need to meet the moment. One example of how we did that at the ELSC is by suing the Dutch government for their role in the genocide that is being committed against the Gazans, and also for their role in eventually the economy of the occupation by not doing a single thing to challenge the involvement of Dutch companies in the illicit settlement economy in Palestine. Secondly, I think that we should make use of innovative legal avenues as well. Like, for example, using anti-money laundering legislation to challenge financial flows that stem from the war crimes that are the basis of the settlements when those financial flows enter the Western financial systems. A good example of that is the criminal complaint that we filed at the European Legal Support Center together with the Rights Forum, SOMO, and of course our colleagues at Al-Haq, in order to challenge the profit that Booking.com was making from hosting and listing accommodations on its website in settlements. What we did there is we used the combination of Dutch anti-money laundering legislation and the Dutch International Crimes Act, which transposes international crimes into the Dutch legal system, in order to challenge the profit that the company is making in the Netherlands from the war crimes that Israel commits against Palestinians. And just to also reiterate what Wesam said earlier, I can tell you that we are definitely dealing with the problem of prosecutorial discretion in this case. It's been, well, going on 2 years now since we filed this complaint, and we still haven't heard back. But there might be news that I will be able to share with all of you very soon, hopefully. So I think that those things are very important. And I think that we really need to make use of these legal avenues. But the cases that I just described are really just the beginning. There are many more potential targets for this kind of litigation. There are many more companies that are profiting from the crimes committed against Palestinians. And for now, all I can say is that we are working very hard at the ELSC to challenge every single one of them. Thank you.
Thank you very much, Daan. Now we have 10 to 15 minutes for Q&A, so we'll open the floor for questions, interventions.
I can only stay a few minutes because
Okay, yes, I give you the priority. So that's on, please.
Well, thank you so much for this very interesting and timely discussion. And I came from Gaza and fully share what just Francesca said. It's the time to stop the killing of protected civilians, to stop this genocide. Since we started our panel, at least 4 Palestinians have been killed. And I don't know how many were injured, maybe 15. And very difficult to count the number of properties that has been destroyed. So time in Gaza is being counted very, very different, with the corpse of children, with the bill of medicine, with the loaf of bread, with the glass of water. That's why it's very important. I think we are witnessing this collapse of what we believed that's very stable and strong in the aftermath of the Second World War. Talking about justice, international law, and Gaza as the genocide that's being executed. And it's the only crime, maybe, since the Second World War that's live-streamed. So no one can deny that she or he did not see what's going on there. However, we have seen this very tolerance vis-a-vis the killings of babies. So now the question is, how come babies being killed and without intervening to put, and it's 20 months, non-stop, ongoing genocide. During those 20 months, at least 270 babies were born and killed during the 20 months. The only interpretation or understanding of why is this, I think it's more related to this, superior culture vis-a-vis inferior culture. So the inferior culture that we belong to, with all its components, babies, children, women, are surplus on humanity. So, I mean, killing a baby or a child, because 75% of those who were killed, more than 60,000 are men and women. And again, weaponization of food, weaponization of anti-Semitism, and the only way to understand this is that fact, that this inferior culture those who belong to it are surplus. I think it's a moment of truth, and I fully share Francesca on this, that it's time to end this. it's not even time to talk about accountability, though it's the key word to understand what's going on, because we were alarming all the way along for decades that the worst is yet to come. If things continue as it is, the way of engagement with that part of the world, give peace a chance, has resulted in this misery. Tolerating war crimes and crimes against humanity have been tolerated and resulted with now execution of genocide on Palestine. That's my message. I think it's the priority now is to stop the killings of babies and children. Thank you.
Thank you, Ustad Wesam. Thank you. Any further questions? Okay, so I take the opportunity to thank you all for joining us for this side event, and also I take the opportunity to thank the panelists for their excellent contribution. Thank you, and as Wesam mentioned and Francesca, this genocide must stop now. Thank you.